My name's Roisin O'Dooley. I'm here on behalf of Bristol Law Society today as a council member. I work with some fabulous chambers such as St John's to organise training like this for you. We've had this in the diary for a long time and we've been very excited, and I think that shows by the sign up that we've had today, so it's really good. We do a lot of different webinars, so please do check Bristol Law Society's website if you're interested in any different practice areas, and we've got a lot with PI, ClinNeg, but other niche areas as well. And I just need to tell you all that this webinar today is being recorded. That should hopefully be of benefit to you all, because you'll be able to access that after the talk today. So you don't need to take too copious notes. Patrick has kindly agreed to share his slides with us after the talk. So next week, sometime after annual leave, there will be some slides and a copy of the recording for you. We've got a few people signed up today with just sort of a single initial or something like that. And for registration purposes, it'd be very helpful if those people could just type to the chair their full name. Just that would help us with our registration if you're able to do that. I can see we're on about 6 minutes past now, so I probably will pass back to Patrick if you want to get going. And Claire, if you want to share the poll perhaps in just a minute. Thank you.
Any late joiners, of course, will have the notes, so and I can address any questions from them as well if everybody bears with it. They may have missed the early part, but that's fine. Good. Okay. So the first point really is that there's been an awful lot of probably heat in the media, not a lot of light, and a great deal of opposition. I think that's very clear to e-scooters, and a great deal of perhaps more background pressure to promote them, and certainly the government takes a positive approach to them, as seen by the Queen's speech recently. So during the earlier stages of their introduction under the pilot scheme, this is the government-sponsored pilot scheme, which has come to many of our cities. In fact, it was in my home city of Bath where I first encountered them. I saw a row of these pink Voy scooters lined up outside the Abbey, and I immediately thought, hang on, I do road traffic, I need to find out what this is all about. So, but the Department of Transport initially gave a very positive gloss to it, where a spokesman said, we believe that e-scooters can offer an affordable, reliable and sustainable way to travel during a time of social distancing, improving air quality and reducing greenhouse gas emissions across the UK. E-scooters could help to ease the burden on our transport network. I think this then gets us into the debate about, are scooters really replacing car journeys or not? I think that's a moot point. Probably doesn't really concern us as lawyers, but nevertheless, it's something that's an issue in the background and often raised. And then I don't often rely on Peter Hitchens' articles in the Daily Mail, but back in 2020, he said that the e-scooter menace is leaving chaos and death in its wake. I think he is right that it certainly has led to deaths. Quite what the position is going to be long term is less clear, but it's certainly not going away. So the very simple situation we're faced with at the moment is that privately purchased e-scooters are in fact strictly illegal. Only the government's legal pilot scheme is legal. It's now been extended to November of this year, albeit that's not a long period of time. I strongly suspect it will either be extended again, especially given the difficulties that the government's facing right now. They're rather busy, but as I said, the Queen's speech has indicated going forward it's very likely to become a permanent fixture on our roads. So despite popular belief, which still seems to be somewhat erroneous in terms of the status of the privately purchased e-scooters, they are not permitted on the roads, and they are only legal if used on private land. There are a number of regulatory and statutory reasons why that's the case. So the Queen's speech in May has stated that the government now intends So the Queen's speech in May stated the government's intention to legalise e-scooters, but subject to certain controls. So, for example, speed control, and that's something already implemented in the pilot scheme. Power, I think that's the two halves of the same coin, lights and other issues. They are yet to work out the finer points of how the legislation will work, and particularly in the crucial matter of insurance, although my own opinion is that they will probably attempt to avoid the insurance issue, but require a provisional driving license. So they're going to create an entirely new legal category for e-scooters. They won't fall under the current category that applies to electrically powered bicycles, for example. One of the questions that I had in advance of this lecture is, are injuries from e-scooter accidents increasing? That is for sure. Some of the latest figures that I've obtained for 2021, we don't have figures yet for this year from the Department of Transport, 1,280 collisions with involved e-scooters. That's compared to 460 in 2020. Now, the number of fatalities was 9 in 2021. That was up from 1 during 2020. The thing is, that's not been differentiated, I think, for legal and non-legal. I suspect it's probably a general figure, but it certainly tells us that this is a problem in terms of road safety, as indeed are many other forms of transport, but equally it is one that is going to grow. And certainly one thing we do know is that the purchase of private scooters has been enormous in the last year. I think over Christmas something like in the region of 1 million were sold by retailers. That's the private ones, which are strictly illegal. So what the government is essentially trying to do is square the circle and recognise that we already have a problem. We have to some degree legitimise it. In essence, they're trying to control it by proposing the full legalisation. So in terms of availability right now, we have them in lots of cities. They are run by a number of different hire companies. So there is a degree of competition, although they have a monopoly in the local area. And we have cities like Bristol, Liverpool, quite a few boroughs in London, all involved already. What are the provisions that apply right now, perhaps to be mirrored in full legalisation in due course? The restrictions are these: you must have a provisional driving licence. The speed on the scooters is limited by the hire companies to 15.5 miles an hour. You have to be insured, and there is currently geofencing, which means that it's a clever technique, which the technology exists now to turn off the engines on these things when you reach the limit geographically within those cities. So that was to prevent them from being ridden outside of the designated trial areas and control it to some degree. Renting scooters, I'm not quite sure what the up-to-date cost is, but it's somewhere around £3.50 for 15 minutes. They're not actually, in my experience, they're not as cheap as might be a bus ticket, if you're thinking of all of this in terms of a cheaper form of transport. So, but that of course would change enormously if they were legalised. It would become much cheaper because you'd be using your own. And it's all operated currently by using an app on mobile phones, so it's very easily accessible, especially to young people. We have a cross-party group of MPs who looked into the issue, and they've recommended that both the currently illegal privately owned scooters as well as the commercially rentable e-scooters should be fully legalised. So that was a cross-party group. It's not entirely pressure from the government side. The Transport Committee's report was very pro e-scooters, obviously noting that they don't have emissions, so they're green. They are affordable, they are accessible, so to that extent they are a pretty democratic form of transport. And they also acknowledge that there are a lot of concerns, particularly from pedestrians and organisations who represent pedestrians with disabilities. I'm sure that the National Federation for the Blind also has had some concern. And those concerns are very real, I think, because those are particularly vulnerable users of the public highway. And the government has at least acknowledged that. But there is, certainly the use of them on pavements, there is existing laws. I mentioned earlier, the Highways Act of 1835, almost ancient statute law, prohibits the use of vehicles on the pavement. There are, the committee also said that riders will not need any form of licence. So that changed, it would seem, with the pilot scheme. And I expect that may be difficult to bring through into legislation if they're looking at broad legalisation, but we'll have to wait and see. The retail cost of e-scooters, I think the fancier ones are possibly in excess of £1,000. You can get them more cheaply than that. So again, that explains why we've seen such a huge increase in the numbers being sold. One can see from the experience of other countries where e-scooters have been introduced. Tel Aviv has had them. They have terrible traffic congestion in that city, and the use of them increased very rapidly within a year. They had about nearly 8,000 on the road. It's understood, I think, that there are about 200,000 e-scooters already in use in the country. I think that figure has probably been exceeded now because of the large numbers that were sold last Christmas. Okay, so the legislative background, this is the rather more involved section on the law. The current pilot scheme is governed by the Electric Scooter Trials and Traffic Signs, Coronavirus Regulations and General Directions 2020, rolls off the tongue. And that amended the Road Vehicles Registration and Licensing Regulations 2002, which came into force on the 4th of July 2020. E-scooters are added to the list of road vehicles, that's Regulation 4. And although it restricts the use of e-scooters on the road to e-scooters being used in a trial, I think that possibly will be amended going forward. Protective headgear was recommended, not made compulsory. I have to say personally, I've never seen an e-scooter rider wearing a helmet. In addition, the provisional licence requirement is set by Regulation 5 of the Motor Vehicles Driving Licences, Regulations 1999. Other measures that have needed to be changed in terms of traffic signs and lanes and so on, the Traffic Signs and Regulations 2016 regulations permit the e-scooters in the trial to use cycle lanes and shared spaces such as pedestrian cycle pavements, but not ordinary pedestrian only pavements. So I'm sure that again that's a concern for more vulnerable pedestrians who are using shared space, and I'm sure they already have concerns about cyclists and mixing with them, but that's the situation in terms of the use of cycle lanes and pavements. And originally, the Department for Transport anticipated that training of some sort will be offered by the rental firms. No specification was made, and as far as I'm aware, no training is currently given. So the reality is in effect dawning on us that this is going to become, it seems to me, a relatively unregulated form of transport, save the possibility that insurance will be required, and the probability, I think, that a driving licence will be required and speed limits will be imposed going forward, much as they are in the pilot scheme. It isn't the first time that we've had electrically powered vehicles like this on the road, although the example I'll give, it looks very different. If you're my age, you may well remember something called the Sinclair C5. Now, this was an invention by Sir Clive Sinclair, who was a British inventor and scientist, and was essentially the man who introduced home computing into most people's houses. He invented the ZX Spectrum and ZX home PC. That was an enormous success. Unfortunately for him, the Sinclair C5 wasn't quite so successful. It was very short-lived. It was introduced in 1985. The only other category that we've had since the 1980s that we've seen more of, perhaps, that has been more successful are electric bikes. They're now sold in large numbers, I think, from cycle shops. They're known as electrically assisted pedal cycles, or EAPCS. And in fact, Clive Sinclair's C5 came within that category, EAPCS. The C5 it looks very much like a children's go-kart, in fact, and I think for that reason wasn't taken terribly seriously, although I think the idea in principle was sound. That had a 250-watt electric motor, and under the original EAPCS regulations 1983, it was not a motor vehicle within the meaning of the Road Traffic Act 1988, so that exempts it from having to be taxed or to have insurance. And so there you can see a previous government, sort of been Margaret Thatcher's government, creating a new category of transport on the road with a new legal status. And I suspect that will be what will happen with the current e-scooters. Interestingly, the electric bikes that we do see quite a few of today are governed by those same regulations from 1983. The big difference, of course, we're coming back to this difficult point about insurance, is that they don't require insurance, as the C5 didn't. And I don't think that's going to be a sustainable position in terms of the e-scooter pilot scheme. I don't think that aspect, the insurance aspect, will be applied to the general legalisation. Grant Shapps himself has said, this is when he was talking as Transport Secretary about the introduction of e-scooters generally, that he wanted to introduce a new legal category distinct from the old EPACS. That's the legal background, and I do think we will see some significant changes, if not in this government, then at some point in the future, in the not too distant future. One of the concerns which was raised in your questions in advance of the seminar was how dangerous are these scooters? And there is no doubt that fatalities have occurred. These are all from privately owned e-scooters. You may have come across the story about the TV presenter and YouTube star Emily Hartridge. Back in July 2019, she was hit by a lorry in Battersea while she was using an e-scooter. I believe in her case that was the result of an underinflated tyre. I think that all of that might be the product because of the fact that we're seeing e-scooters in use by younger people, maybe who aren't used to vehicle maintenance, maybe not even bicycle maintenance, but that there clearly was an issue there. About safety. And April 2021, there was a story about a 3-year-old boy who suffered serious injuries hit from behind by an e-scooter while on a pavement in Feltham. And May 2021, 6-year-old Jamie Smith, who suffered a fractured skull, very nasty injury after being hit by a teenage e-scooter rider in May of last year. As I said, those are all the currently illegal private scooters and not hire scooters. What one can see that it is a serious issue going forward. So in terms of, I have provided lectures for operator insurers and solicitors working with them. What's clear in terms of e-scooter incidents is that most involve a collision or alleged collision with another vehicle, so a straightforward road traffic scenario. A lower number involved no other vehicle or party, and that sort of claim would be stemming from an injury to the rider as a result of the rider falling from the scooter due to rider error or alleged scooter malfunction, a sort of defect with the machine. Some involved the rider falling as a result of hitting a pothole. I have seen that accident in Bath. A couple of young Italian gentlemen who were clearly visiting the city and decided to have a fun day on an e-scooter. One of them hit a pothole, I think, and had quite a spectacular fall from it. So then we have a smaller number which have involved the rider falling as a result. A smaller number involving a collision or alleged collision with a pedestrian, and a very small number involving collision with property. And even fewer involved a pedestrian tripping on an abandoned scooter. Now that is one concern that's been aired quite widely in the media, particularly when it comes to blind pedestrians, or indeed older people who may not be so aware of what's around their feet perhaps, but certainly for blind pedestrians that is a real concern, because of course currently the pilot scheme scooters are being dumped quite legitimately under the scheme, it seems, at various spots, and then they're collected up later by vans and taken back to the higher points. But even those higher points are simply an area on the pavement. They're not, unlike the Boris bikes that we saw introduced in London and many other cities, they're not at a specific charging station where it's a large installation. They are simply lined up on the road, or when they're left after use by the rider, they're just sort of discarded on the pavement or the side of the road. So perfectly understandable concerns are being raised there. Hopefully I'll be able to give you some examples, practical examples of how e-scooter accidents might play out in terms of the law. Some of this will include insurance issues as well, maybe of varying relevance to you depending on your practice. So the first example is taking up what we know to be the vast majority of incidents, which is a collision with another vehicle, and this is the case of Joe Skuteski and Jane Smith. Joe on a weekend jolly with his friends to Bath. They'll hire 4 e-scooters rented out by Scooter Co. They come around a bend in the road, and Joe, who is in the lead, collides with Jane Smith's car as she emerges from a side road. Joe comes forward to Scooter Co to make a claim for a nasty hand injury. So we're in safe territory, I think, here for most of us, that most of these cases are going to involve other vehicles. Most of these cases will look very familiar to the sorts of road traffic claims that you're currently handling. So the tortious standard of care will be identical. It'll be the reasonably competent driver / reasonably competent rider. There won't, I think, be any concession made for age. Obviously under the pilot scheme, you have to have a provisional license anyway, so that restricts the age that is using, age of people using the e-scooters. If it can be shown, for example, that Joe was doing everything a competent driver would do, so he's observing a safe speed, it'll certainly be under 15.5 miles an hour. His position in the road, that might be more tricky. They do tend to range quite widely, as I've seen, and that Miss Smith was not keeping a proper lookout as she emerged from the side road, often the case in these sort of side road vehicle collisions. Then Joe has a reasonable prospect of success. However, given the likely popularity of the e-scooter with young people, and the fact that only provisional licenses are required, and that most of the riders will not have used an e-scooter before, it seems inevitable that plenty of users will fall below the reasonably competent standard in causing accidents. Doesn't necessarily mean that it might not be a case of split liability, of course. So as a claimant, solicitor, that still would apply. It may well be worth taking a case for that reason. There is strong potential for e-scooters to come into conflict with other e-scooters. Again, they'll both be required to meet the tortious standard common law standard of care, which is reasonably competent. And cyclists and pedestrians may also be involved, particularly given the fact that these e-scooters under the pilot scheme are permitted to use cycle lanes and other mixed-use areas. Really practical advice, I think, in these sorts of cases is just get as good an account, good and detailed account as you can from the rider as soon as possible. And I think because this is a new area, I think I would perhaps devote a bit more time to it than you might do with necessarily an ordinary vehicle. It'll be perhaps important to get some sketch plans, photographs of the accident locus, etc. Again, these are things that we routinely do with more complicated road traffic cases, of course, but those would be very useful indeed, I think. And of course, look for other witnesses, not just independent witnesses. This is a general point. I often find that friends or relatives have been excluded from consideration as a witness because of their close relationship with a claimant. That doesn't necessarily invalidate their evidence. It all depends on what their evidence is, how credible they are, etc. So don't ignore that. Could be useful. Probably unlikely you'd see many bystanders getting involved, but that's a possibility if you could get a witness through that, whether any numbers were given, etc. At the end of the day, this issue is a matter for the court. It will determine what the factual matrix is on the balance of probabilities, and credibility will be the key, particularly in cases of rider against driver cases. So an early conference might well be a sensible plan. If we move on now to unidentified riders and third-party claims, because of the nature currently with the pilot schemes and obviously e-scooters that are privately purchased don't come in to the MIB scheme because of the fact they're not legal. There is an issue, I think, at times with riders not being identified. They don't really have much of a stake in all of this. The scenario I've come up with here, example 2, Professor Annie Johnson and Scooterco and the MIB. So Professor Johnson is driving along the street in Oxford when she encounters a single female on I mean by that one woman on a scooter, so she can see that it's one of the pilot scheme scooters, wearing a graduation gown and mortarboard, who drives off the pavement straight in front of her and causes a collision. It sounds like a very nasty end to a graduation day. But the rider doesn't stop, but drives away without giving any details to Professor Johnson, who's been left in the position of suing an untraced rider or untraced driver, as we're more familiarly aware of them. What's the situation there? Well, many claims are reported by the operators, often reported to the insurer, that is, often reported by the third party and not the rider. That's not surprising because the rider has no financial interest in the scooter or the underlying insurance policies that are operated under the scheme. Rider engagement in that sort of case is going to be very difficult, and it may be that you'd be defending a claim without the rider as a witness, which is going to make the job very difficult. When incidents are notified, it's often not accompanied by details of any riders present in the area at or around the time of the alleged incident, which can delay investigation so that the insurers are having some difficulty pinning down who it might have been. You would think that with the technology behind all this, the app and so it might be a straightforward matter. It isn't. Assuming that the rider of the scooter can be traced, which might be possible if enough information can be gleaned by the operating hire company, then the case will proceed broadly as we saw in the case of Mr. Skuteski. That was the first example. If the rider can't be found, then and the claimant only issues against Scooterco, then the claim will fail. Not necessarily a principle of law that everybody is aware of, but it is a leading case. It went to the Supreme Court, the case of Cameron and Liverpool Victoria Insurance Co. Limited. The ratio of that case is that it is not possible to bring a claim in the county court or the high court or any court where the identity of the negligent driver is unknown, even where the vehicle has been identified and there is a policy of insurance covering that vehicle. The identity of the owner of the vehicle is also irrelevant, since the claim must be advanced against the tortfeasor. You've got to know who's committed the error or the negligence. A claim will not succeed where it is advanced against the owner of the vehicle, who cannot additionally be identified as the tortfeasor. So here we're really getting into the whole matter of the MIB, because that's what it was created to resolve. It was to prevent those who are injured from being left with nobody to recover from, to recover damages from, where they don't know who the driver was. So we're looking here then at the MIB's untraced and also the uninsured drivers agreements. It seems to me that where e-scooters fall within the MIB schemes, they probably are under section 151, which is the definition of mechanically propelled vehicle. I think they are a mechanically propelled vehicle. That's what they look like, that's what their purpose is, and the rest of the definition under section 151 is a mechanically propelled vehicle intended or adapted for use on a road or other public place. So it seems to me that, strictly speaking, they should be brought with, they are being brought within the MIB agreements. So under section 151, no doubt you're all very familiar with this, the Road Traffic Act, the road traffic insurer will have a contingent liability as Article 75 insurer, even if they're not liable under the policy, and the extent of their liability mirrors that of the MIB. So where a named insurer has been identified, and you would know that with the pilot scheme, because as far as I can tell, it's one insurer for that area, for that area scheme, because they're operated by one company. Where you've identified the insurer, the MIB has identified them, or it has identified itself as an Article 75 insurer, proceedings can only be issued against the MIB, who will pass the claim on to that insurer. So that's the first step we need to issue against the MIB. No direct cause of action exists between the claimant and the identified insurer. Liability only arises through that company's membership of the MIB. Clause 3 of the 2015 agreement reiterates the MIB's obligation to satisfy unsatisfied judgments, and the defences that are available are many. So if you have a case that is an MIB case with an e-scooter, it isn't going to be an easy ride, if you'll excuse the pun. The first thing you have is the MIB can avoid judgment if no proper notice was given. So you need to look at the terms of the agreements there. If the accident didn't arise out of the use of the vehicle on a road, that could be an issue, as we've already discussed, because of the fact that often we're seeing the use of e-scooters on pavements. The policy has been correctly cancelled prior to the accident or 15 days to expire from the lapse date. That probably applies more generally to road traffic insurance. A declaration from the court the policy was void, probably not so likely to occur at the moment anyway. The claimant knew or ought to have known that the vehicle in which they were travelling was stolen or uninsured. I haven't seen any issues raised in the media about the hire scooters being stolen, so I'm not sure that would necessarily be raised currently as a defence, or any part of a claim which comprises a subrogation claim is not payable. So those are the defences that you might come up against if you're suing the MIB involving an e-scooter case. And then we have my next example of uninsured riders. At the moment, that really won't apply, as I say, generally, because unless what the hirer of a pilot scheme scooter is doing is outside what they ought to be allowed, or they're allowed to do under the scheme and under their contract with the hire company, that may then invalidate their insurance. But there won't be so many of these. It's something that might well become an issue going forward, or more commonly an issue. So this is the case of fictional of Lauren Wheely and John Roberts. Now, Miss Wheely is riding a scooter in Birmingham, which is driven by her boyfriend Pete Reckless. They have been out drinking with friends, always sensible, on an e-scooter, and Pete rides at top speed, albeit that's only 15.5 miles an hour, veering across onto the opposite carriageway and into Mr. Roberts' car. Sorry, that should be, yes, Mr. Roberts' car. And this is John Roberts, who's the defendant. Pete is breathalyzed after the accident by police who attend the scene. And he's found to be over the drink drive limit. So this is going to put them definitely outside of the likely terms of their insurance policy provided under the hire scheme. The first issue is knowledge of passengers. So here we have Miss Wheely, she's on the back, I assume, and the 2015 agreement, passenger claims only remain excluded by clause 8. if a claimant voluntarily allows themselves to be a passenger in a vehicle, and either before the start of the claimant's journey in the vehicle or after its start, the claimant could reasonably be expected to have alighted from it, and they knew or had reason to believe the vehicle was stolen or unlawfully taken, or it was being used without insurance. Now, I think most courts would assume that somebody like in Miss Wheatley's position ought to have known that with Pete's reckless driving it while drunk, that was not going to be acceptable to the hire company. So I think that would be a reasonable defence in this case and likely to be made out, unless Pete Reckless is so good at concealing the smell of alcohol in his breath, or maybe she wasn't present immediately when he was drinking. I don't know. That might be then introduce some other issues about what she knew. But generally speaking, that's going to be a difficult case to win for the e-scooter passenger. Apart from anything else, certainly under the pilot scheme, you're not meant to take passengers. So our next slide, knew or ought to have known. This is a key principle in MIB case law. The case is White and White, 2001 House of Lords case. It's essentially knowledge by a passenger that a driver was uninsured is either from actual knowledge, so perhaps Miss Wheatley was drinking with Pete, she would know how much he drank, or the passenger having information from which they drew the conclusion that the driver might well not be insured, but deliberately refrained from asking questions lest their suspicions should be confirmed. So what that means, of course, is that the merely careless or negligent are not excluded. And if Miss Wheatley had joined Pete after he'd stopped drinking and he didn't tell her he was drunk and she hadn't seen how many drinks he'd taken, she might still be fixed with knowledge that he was drunk in charge of that scooter nonetheless. Perhaps on the basis she ought reasonably to have assumed he was drunk because he smelled of alcohol or walking in an unstable manner, etc. Then we have the issue of consent. And the key issue here is, key case law here comes from a case called Pickett, Pickett MIB 2004, that's a Court of Appeal case. Claimant had suffered significant injuries following an accident in her car, at the time being driven by her uninsured boyfriend. Her boyfriend had started to make handbrake turns, and the claimant had asked him to stop the turns and to stop to let their dog out, who was in the back seat. However, he carried on. The Court of Appeal found that she had not withdrawn her consent to being driven in the car, as she had not unequivocally asked to get out of the car. As such, the MIB successfully repudiated liability. So, teasing out the difference between actual knowledge and claimants who were just careless about the state of knowledge will often be quite difficult. So you need to investigate the evidence from the lay witness evidence very, very carefully in cases against the MIB. It's a question of fact for the court. If there's a slight variant here, if Miss Wheatley's case above, the accident was caused by her boyfriend doing tricks in the road and she failed to tell him to stop and let her off, then she may well find her claim dismissed. Child claimants, probably going to be a much harder type of case to decide. Child of 14 may well be accused of knowing their co-rider was drunk. Background to child knowledge about liability. They can be liable for their own fraud at the age of 7. That's a very, very old case. Watts and Creswell, 1714. Each case is going to turn on its own facts. We know this is a big issue because so many young people are using the privately purchased e-scooters. And ultimately, I'm sure there will be cases where the legalised scooters are being used by youngsters below the normal age. So clearly a child is in a difficult position if their father is drunk and they're told to get back on the scooter. In that situation, they're probably not being voluntarily carried for the purpose of the agreements. And in those circumstances, liability as an Article 75 insurer will be quite difficult. So then we have the burden of proof. The burden of proving knowledge in these situations, knowing that it was being used in the way that we've discussed in those examples, is on the MIB or the Article 75 insurer. The key clause in the agreements is 6.1e, and pursuant to clause 6.3, in the absence of evidence to the contrary, proof by the MIB of the following shall be taken as proof of the claimant's knowledge that the vehicle was being used without insurance. The claimant was the owner or registered keeper of the vehicle, or had caused or permitted its use, that the claimant knew the vehicle was being used by a person who was below the minimum age at which he could be granted a licence, and that the claimant knew that the person driving the vehicle was disqualified for holding or obtaining a driving licence, or that the claimant knew that the user of the vehicle was neither its owner nor registered keeper nor an employee of the owner, etc. And pursuant to clause 6.4, it said there knowledge which the claimant has or ought to have for the purpose of paragraph 1e includes knowledge of matters which he could reasonably be expected to have been aware of had he not been under the self-induced influence or drink or drugs. So it's no defence that you're high and therefore didn't understand what was going on. Under the 2015 agreement, the words knew or ought to have known have been changed to knew or had reason to believe. So this remains a constructive knowledge exclusion, and the judicial considerations which I've set out already will remain valid. By clauses 8.3 to 5 of the 2015 agreement, proof of knowledge previously provided under 6.3 of the 1999 agreement is retained, as is the inability of the claimant to rely upon the fact that they were incapacitated by drink or drugs. So aside from drink or drugs being taken, if the claimant could reasonably be expected to be aware of the matters in 8.3, this can amount to relevant knowledge. So all of those issues are relevant to an MIB defence in an e-scooter case. Another example is if, in Miss Wheeler's case, if she ought reasonably to have known her boyfriend was under age for the use of the e-scooter, didn't have a provisional licence, in my view, she'd almost certainly be fixed with knowledge that he was uninsured, and thereby her claim would be defeated. So now I'm going to look at the insurer's ability to recover from its insured. This is example 4. Not learning from his mistakes, Pete Reckless goes out in Birmingham the following week and hires a Scooter Co. scooter, picks up his friend Johnny Careless, and they go for a ride along Broad Street on a Saturday night, which, if you've been to Broad Street, you'll know is a very, very busy street indeed. Halfway through their jaunt, Johnny pesters Pete for a go on the scooter. Pete stops, allows Johnny to drive the scooter for 100 yards until he loses control, crashes into a parked car, so not a moving vehicle, with an occupant, but a parked car, injuring Pete. Johnny is only 17 years old and therefore below the age limit under the Scooter Code policy. Where do we stand then from the insurer's position? Section 1518 of the RTA, Road Traffic Act 1988, allows a road traffic insurer to recover its outlay from any person, including its policyholder, who's caused or permitted the uninsured use of the vehicle at the time of the accident occurred. Most often that's going to cover the sort of situation where the owner, as in the example I've given, who for whatever reason, possibly they're drunk, allows the uninsured driver to drive the vehicle but is then injured as a consequence. So the case law in respect of the Churchill and Wilkinson, that's a relatively recent case, 2010 Court of Appeal, and again on its return to the Court of Appeal in 2012, the court held that the Road Traffic Act insurer cannot refuse the claim, but can seek a deduction to reflect the injured passenger's blameworthiness. So it doesn't entirely exclude the possibility that you've got a good claim, but it won't necessarily be the case that you're going to recover in full. Clause 10 of the 2015 agreement, the MIB makes it clear that under no circumstances in such a case will the MIB be liable for all or part of any reduced outlay from the insurer. So they keep themselves clear of that. Then there's the issue of joining the MIB. In the 2015 agreement, clause 13.1 now makes it a prerequisite to the MIB's liability that the MIB are joined right at the outset. So when you're issuing proceedings, they need to be second defendant. The correct application form's got to be used. So you need to make sure that it's done through the application form. As it has been previously with the MIB, technical slips in terms of the paperwork can be a bar to you bringing the claim. Claimants have to be prompt in notification and service of pleadings, and as soon as they become aware that there's no RTA insurer in the frame. So do pay attention to those issues if the MIB are going to be footing the bill if you win. To the prosecution of proceedings then, hold on, I've got an example. Sorry, I just want to give you an example here in the case of joinders. So Pete Repus's case, which we've just looked at on Broad Street, it was not a parked car involved, but another driver who'd not got his headlights on, so an alternative scenario. In that case, there would clearly be an arguable case against the third-party driver, and the MIB can insist on the joinder of that party. And if that's successfully done, then it turns the claim from a likely unsatisfied judgment into a satisfied one, releasing the Article 75 insurer or the MIB from liability. So you're then back into a regular type of a defendant situation. Okay, so in terms of forgive me, I've just got out of step with my slides slightly, but in terms of the degree of liability, if there is a meaningful degree of liability for the accident caused by another party who's properly insured or whose insurers have an RTA liability, then the Article 75 insurer and the MIB will escape liability, as we said already. For example, if the uninsured driver is 10% to blame, and an identified insurer driver is 90% to blame, the latter's insurers must meet the whole of the claim, as the Article 75 insurer MIB is only required to meet unsatisfied judgments. That's the underlying principle of the scheme. Obviously, untraced or uninsured drivers wouldn't respond, so it's unsatisfied judgments that are being dealt with by the MIB effectively. So an example of rider-only claims. This definitely has occurred. I know from my dealings with one of the pilot scheme insurers. Example 5, Sandra shocked against Scooterco, and Sandra's on a daytime shopping trip in Liverpool with her mum. They hire Scooterco scooters, Sandra travelling along the Albert Dock when her scooter's brakes fail and she careers into a wall. And this really introduces into today's lecture the increasingly resorted to option of pleading res ipsa, which to some degree over the years had fallen into disuse, particularly in employers' cases where there were a great deal of regulations that dealt with defects in equipment. And of course, since the ERA in 2013 coming in, most of the European regulations have gone, and those did provide for strict liability for defective equipment. But in a road traffic context, you don't often see res ipsa. It does sometimes come up, and there are some older cases. Just to look at where res ipsa is derived from, the case that we usually look to is Scott and London and St Catherine Docks Code, very old case, 1865, well before even motor vehicles existed. And this was a nasty incident on the docks. A bag of, or a load of bags of sugar fell from a crane. And the judge in that case said there must be reasonable evidence of negligence, but where the thing is shown to be under the management of the defendant or his servants, and the accident is such as in the ordinary course of things does not happen, if those who have the management use proper care, it affords reasonable evidence in the absence of explanation by the defendant. And that's the important aspect of this, the absence of explanation by the defendant, that the accident arose from a want of care. So how do we apply this in practice? You can infer negligence if the accident doesn't normally occur without negligence. The defendant can defeat a claim of pleading of res ipsa if the alternative explanation is plausible. And there are three ways that the presumption of negligence can be rebutted. You can demonstrate an alternative cause. So let's say an engineer investigates a vehicle or scooter afterwards and finds that there was some other reason than negligence, and that then switches the burden back to the claimant. next point about demonstrating about presumption being rebutted is even if res ipsa applies, the defendant may show they exercised all reasonable care, even though they cannot show how it happened. And if, for example, in this case, if Scooterco disclosed reasonable inspection and maintenance records, and certainly there's nothing in those records that shows there was a defect or problem that they failed to address. But if they can show, much in the way that you may be familiar with in Ward and Tesco type of cases, if they can produce regular inspections, they can produce regular maintenance records, then it's likely that the res ipsa pleading could be defeated. So in this instance, if Scooterco does that, it's likely that Ms. Schock's claim would be defeated in terms of being a res ipsa pleading. That isn't the end of the story. We now have, since the 1980s, the Consumer Protection Act. So a claimant could potentially bring a claim pursuant to Section 2.1 of that Act, which does give us strict liability. A hirer can be a supplier under the Act, and a supplier has an easier time than a product manufacturer. So as you may be familiar, if you've done a CPA type of case, you contact the hirer, they say, we were supplied with it by this supplier, they may have been an importer, and it can go down the line ultimately to the manufacturer. There can be issues with those cases, of course, in terms of trace and identification, but usually what happens is it stops at the last one if they can't demonstrate who it was. So that's an alternative in that sort of scenario with a defective machine. So then we can look at one of the other categories of accident that seems to be cropping up, which is claims against a rider by pedestrians. Here we've got example 6, Mrs. Ina Sharples, no relation, and Pete Reckless. Pete Reckless has turned into public enemy #1 on an e-scooter and has hired from Scooterco for the 3rd time. You would think they'd have spotted him by now, but they haven't. And he's run down 85-year-old Mrs. Sharples as she's crossing the road at a junction. She contacts solicitors who bring a claim on her behalf against Pete and Scooterco's insurer. This time, Pete's sober and he's not doing anything out of the ordinary. And so his driving and indeed this accident would then come within the highest company's insurance policy, so he's not in breach of contract there, and he wouldn't be classed as an uninsured driver. So this is going to be a straightforward claim, I think, given the presence of a regular road traffic insurer, and hopefully, given that Pete seems to have given up drink and drugs and is trying to reform himself, he'll cooperate in producing a witness statement. So you'll have your lay witness, you'll have your rider in court, hopefully, again, who will be able to defend the claim against him. There have been changes, however, in relation to highway code. I suspect most of us who are working in road traffic will be aware of them by now. Lots of people aren't. I regularly have to I regularly stop at a junction. This is one of the new rules under the Highways Act, under the highway code, that a pedestrian has right of way at a junction. So when you're pulling off the main road into the side road, you have to stop for them to cross. And frequently I have this kind of very English situation where I'm saying off cross you go, and the pedestrian's going, no, you come in first. And I don't want to get involved in discussions about which rule of the highway code they ought to be observing or I ought to be observing. Life's too short, but clearly it's not getting through to the general public yet. And it may take some time before people do realise what the changes are. But certainly before those came in the autumn of 2021, and let's be clear, the highway code is often taken as good evidence in negligence claims. Some of it, I think it's usually where it's highlighted in red, is actually the law. But even the parts that aren't are taken as good evidence in terms of breach of duty. So the new rules strengthen rights of way for both pedestrians and indeed in other respects to cyclists, and I suspect that e-scooter riders will benefit to some degree from that, particularly the 2-metre clearance rule that's come in. These are issues to be aware of where you've got a case of an e-scooter and a pedestrian, and pedestrians in general, of course. So then we've got a discrete category. I suspect this won't bother too many of us in the long term, but they're certainly possible, and they're certainly occurring through the pilot scheme, claims by third parties for damaged property. So this is example 7, Herbert Anger and Scooter Co. Mr. Anger returns to his parked Rover 75 to find a dent in the driver's wing, and Pete Reckless is stood next to it with his e-scooter, scratching his head and looking guilty. As I said, there have been examples of claims where third parties have made allegations about damage to a vehicle that they assume was caused by a scooter because one was parked up nearby or they were observed in the area at the time. Certainly the pilot scheme insurers had some suspicion that not all of these were genuine, as you can appreciate. But in Mr. Anger's case, he's got no problem identifying the rider, Pete, because he is stood there. And because Pete is now completely a reformed model citizen, he gives him his name and address. If Mr. Anger is only aware it was a Scooter Co. scooter, I think that's much more likely in most cases. Unless it can be determined who the rider was by means of investigation, he'll be in the same position as the claimant in Cameron and will have to pursue a claim against the Article 75 insurer or MIB. If the rider is not available, as in any claim where insurer suspicions are raised and you're defending, look out for inconsistencies in the evidence, look out for the sorts of red flags that we often are asked to consider. So claims history of the driver of the motor vehicle that the claim is made in respect of, perhaps where the location is it a remote location? These sorts of things might be of some concern. So again, not one of the main groups of claims that we're so far seeing, but there certainly are out there. I think this sort of thing is more connected to the pilot scheme because of the nature, as already described, of the way that the scooter hire operators allow you to use the scooters. There's no criticism if you just leave it on the pavement somewhere within the geo-fenced area. Example 8 then, John Williams and Scooter Co. Mr. Williams walking down the street with his new date Joan, who he's besotted with, as they're crossing a private company car park on approach to the Wetherspoons pub, where he's taking her on their date. He fails to notice a Scooter Co. scooter, which has been left lying down on its side, trips on it, and he is injured. And one of the biggest concerns about the pilot scheme has been the danger that they pose to partially sighted and blind people and others who are vulnerable from the scooters just being left lying about. One might counter-argue that by saying, well, there are plenty of obstructions on our town centre pavements. We've got bollards, pedestrian bollards, utility boxes, etc. But e-scooter being added on to that large number of hazards that the more vulnerable pedestrians are already facing. So again, with the case of third parties tripping, if the reason that the scooter's been left on its side is down to the rider, almost certainly going to be, isn't it? They're not necessarily left in areas where people pick them up and start messing about with them. It seems to me in most cases, if it's on its side and it's been left like that and you can show that, then Mr. Williams is in the same position as the claimant in Cameron. But depending on precisely where the accident occurs, you might struggle to establish an Article 75 MRB claim because of this a dispute about whether or not it's a vehicle on the road or in a public place. And there's quite a considerable amount of case law on this. It's obviously a matter to be determined by the court. We can have a look at some of these examples. I've given you quite a long list just to try and be as comprehensive as possible in the notes. But for example, 1988 Valentine Burns, the car park of a pub. So that is a public place, and for the purposes of this sort of accident, a hotel driveway, which might be seen broadly as similar to a car park. A multi-storey NCP car park, a lot of these are car parks. But there are other examples as well. An internal roadway at a university campus, that's Cowan and DPP. Privately owned land next to a private club, Pew and Knipe, 1972. Oh, sorry, Pew and Knipe is not a public place. But another example of a public place is a school playground, Roger and Norman, 1994. So you're going to need to look very closely at the particular facts of the case and try and fit that into some of the previous case law. But do have a look at that long list that I've given. There are some interesting examples there of what are and what aren't public places for these sorts of accidents. So we're going to move on to the issue of contributory negligence now. And clearly that's going to, yes.
Sorry, just doing a bit of a time check because it's 2:05 and some may need to leave us.
Yes, of course.
Do you want to highlight the most important parts of what you've got left? And I know we've got 12 questions. I don't think we'll be able to address all of those.
No,
but we might be able to address them afterwards.
I'll begin to yes, I'll begin to type now. So contributory negligence, you'll be well familiar with the principles. They are very likely to apply. The helmets issue, I strongly suspect that it's a possibility that helmet regulations might be introduced, but we haven't seen them with cyclists so far. Having said that, cyclist cases have gone through in the courts where Freeman Butcher, or the principles of Freeman Butcher, seem to be applied. That's Smith and Finch, and have a look at that. Claims not involving third party or personal accident. So this is really only much of an issue, I think, if you're a defendant and claims being brought on the policy and there's some sort of issue there. In terms of there are some sections of the notes you'll see which are more about insurance. If you are a defendant and you're having to deal with issues like that, whether insurance will respond, an insurance policy will respond, please have a look at those. You need to know really that the accident needs to be identified as soon as possible, but there are other requirements often too in the policies. Do look at the individual policies. The whiplash reforms, we've all been very troubled by these if you're a claimant solicitor or barrister, and the aim is to create new portals being created essentially for the lower end of the PI market. And I think the way out of this, if you're representing e-scooters, is that e-scooter riders will probably be classed as vulnerable road users, and 26.6a is the part of the white book you need to look at. So if you're a child, a protected party, using a motorcycle, pillion passenger, bicycle rider, riding a horse or a pedestrian, and I think e-scooters are going to fall into that, at least by analogy with cyclists. And what that means is that you avoid the portal. It's not specifically mentioned, possibly in future versions it will. And so that's my view. You'd be within the vulnerable road user category for the ordinary MOJ portal. So that's the end of the lecture. I hope that's been helpful. Do you have any questions? I think that there may be issues for particular individuals among you, I don't know. Hopefully the lectures covered most of them. But do please, if you've got any questions, do please use the opportunity.
Patrick, I think I'm the only one able to speak, so I'll have to read out what we've got. So I have had some feedback saying very clear and informative, so thank you very much, and I would concur. Been a very thorough and interesting talk. I'm not going to be able to cover all of the questions now, and in particular we've got one attendee who's got quite a lot, so I think Claire said she'd probably forward that to you in a separate email for you to perhaps get back to them.
Yes, I can do that.
I've got some questions from earlier on in the talk. I'm not sure if they've been addressed now. E-scooters are permitted to ride on cycle lanes or pedestrian shared pavements, but not pedestrian only pavements. Is that the case?
That is correct, yes. Unfortunately, it's an area of law that's much abused by cyclists and has been for years, possibly due to the death of the cycling proficiency test in schools. Yeah, Section 7 of the Highways Act 1835, it's long been the case that you can't ride on the pavement. That would be the answer to that one, I think.
Brilliant. And in terms of liability, is it the standard care of the reasonable competent driver of an e-scooter or a car driver?
It would be the reasonably competent rider of an e-scooter, yes. And this is obviously going to be a new category that judges are looking at. There isn't currently a test to ride an e-scooter, so it's probably going to be a more or less a common sense approach the courts will take to that, informed to a degree by how they deal with the standard of care for reasonably competent drivers.
Thank you. We've got some people here who've witnessed other people allowing others to use their hired e-scooter as per your example.
Yeah.
Is it possible that the e-scooter insurer could then avoid a claim on the basis the rider didn't have permission from the company to use the e-scooter?
I think very much so. That was really the section of the talk we were talking about earlier, where we had the girlfriend and the boyfriend, and he's riding it and he's got her on the back. So I think in those situations, you are into probably a situation where you're after the Article 75 insurer and the MIB, as opposed to the road traffic insurer per se. The one.
Yeah. Thank you. I think you've addressed this as well, but it's interesting to go over again. So some of the Limey scooters in London have been found with deflated back tyres. We're not sure, how often they're being checked. And obviously the users wouldn't know what to look at. And
no, that's probably true, isn't it? Yeah.
The black mudguard is obscuring the view of the tyre as well in some cases. So
yeah, I think I've noticed that. Yeah.
How are riders protected if they're injured and the e-scooter was damaged? I do believe that you've covered that one off.
I think we probably have, haven't we? But yes, I mean, it's probably going to be a res ipsa type of scenario. Very unlikely that the defendant are going to be able to show evidence that the riders somehow tampered with the wheels. It's just not very likely. So the burden is then on them to demonstrate that they have been maintaining the scooter properly, and they'd have to disclose. You need to look at what disclosure they can provide. If they've had 25, an individual scooter involved has had 25 riders over a period of a week or 2 weeks, and this thing hasn't been looked at, then probably there would be a case of res ipsa there, I think.
Thank you. A question from me, I suppose, is there any way for us to see the insurance policies ahead of being in the position of having a claim? So I suppose, have you looked at any of these voice scooter websites? Are there any policies that are available for us to look at?
I think it would be part of ordinary disclosure. As far as I'm aware, there is no sort of standard contract, although it wouldn't surprise me, because I think there are only a couple of large insurers involved, that there isn't a high degree of consistency between the different pilot company schemes, between the different companies and their insurance policies. They are probably broadly going to look similar. I think you're going to have to really obtain them as part of disclosure if there's any particular doubts for any reason, pre-action disclosure, but it should normally be dealt with in the normal way you would, and if it's relevant, and it might well be in a case of hire, then that probably would become disclosable.
Yeah, brilliant. Well, thank you so much, Patrick. That was really wonderful. So as I said before at the beginning of the talk, Patrick is a barrister from St John's Chambers, specialising in PI, Clen Neg and inquests. And he's obviously got a lot of interest in this particular area. So if you are considering a claim and you want some advice, his details will be in the CV provided after the talk. That will all go out next week due to some annual leave. So you'll get a copy of the slides, the presentation and his CV. Thank you all for your really interesting questions. I think some of them were sort of preempting what Patrick covered later on. So there's been perhaps a bit of repetition there, but Patrick can then see, I suppose, what we were most interested in as the live issues. I just want to do a bit of a plug for Bristol Law Society as well, just to say we've got a couple of great events coming up soon. Our summer party on 14th of September and our annual dinner on the 3rd of November. So if you want to come and sort of network with the likes of our wonderful barristers and other members, then please do have a look at the Bristol Law Society member website, and you can download the forms there. Patrick, was there any sort of closing remarks that you had before we let everybody get on with their days?
Not really. I think the important thing is not to be too frightened of these scooter cases. They are subtly different. A lot of it will look the same. And perhaps you'll need to devote a little more time to these claims, but many of them will represent good claims. Many of them will be defensible. I can't afford much reassurance to those representing vulnerable pedestrians. I suspect that they are here to stay, but the government isn't ignoring that, I think, or shouldn't do. We'll see how things pan out going forward. But thank you so much to Roisin and Claire for organising today's talk, and thank you all for attending.
No, thank you for coming to speak. It's wonderful. Thank you very much. And thank you everyone for attending. Enjoy the rest of your day.